Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. Today's question is, help! I've received a claim letter by a liquidator. They're asking for money from me. What should I do? So, the first thing to work out is, what is the liquidator claiming against you for? Is it for a debtor accounts receivable type of claim or amount? Or is it an unfair preference payment, an uncommercial transaction, or some other voidable transaction? Or is it perhaps for insolvent trading if you're the director of the company, or even a former director of the company? The next thing to work out is, do you dispute it? Do you agree with the amount? Especially if it's a debtor claim amount and you agree with the amount, then obviously the answer is just pay it. And yes, you are entitled to pay the liquidator, and that will discharge your debt to the company. What happens if you don't agree, and what happens if you dispute it? So then there become a number of considerations. Firstly, is it worthwhile to dispute it? What is the amount of the claim? And what's the time, cost, energy involved in fighting it? This is particularly a consideration for low dollar value claims. For example, there might have been some faulty goods that were delivered to you. If you explain it to the liquidator that these items are faulty, perhaps there can be some sort of settlement just through negotiation and conversation. They'll probably ask to see some documentation to support whatever you're saying, so that they can see you aren't just making it up. What happens if it's a different sort of dispute? Something like an insolvent trading claim, or an unfair preference claim, an unreasonable director related transaction, or some other voidable transaction claim. Now, there's a few things to consider from here. Firstly, what are they claiming for? What is the amount? How have they reached that amount? Have they done a bit of an estimate, or have they based it on certain individual transactions? Now, if they've based it on either an estimate or certain individual transactions, do you agree with that? Do you agree with the calculation? And look, I'm happy to have a look, just an initial look over at no cost, just to let you know how it might have been made up, or try and find out how it's been made up. Then it becomes, okay, do you agree with that, or do you not agree with that? And if you don't agree with it, and you've decided it's worthwhile, then it's time to get some solicitors involved. I highly recommend solicitors who are experienced in insolvency rather than general solicitors, because professional advice is so niche these days. You want somebody who knows all the different levers, for want of a better description, all of the different elements to consider to provide you with the best defense possible. One of the other things to consider is, what's at stake if you fight it? What is the estimated likely time and cost to do so? And what's at stake if you don't? So I'm specifically thinking insolvent trading claims or voidable transaction claims against directors individually, or former directors where, for example, their family home or other assets might be in their name. So that would then be at stake if they weren't fighting it. So I would recommend them speak to a solicitor, an insolvency solicitor, in that case. I hope this helps point you in the right direction. There's lots of elements to this. I hope this has been a useful summary.